Hey everybody, welcome to the Bold Today show. I am JD Houvener, your host and owner here at Bold Patents Law Firm. I am a patent attorney and I'm happy to answer any process level questions, hypotheticals related to patent law. And I welcome all of you entrepreneurs, business owners, or inventors, right? Curious about what it takes to move from an idea to an invention to getting a patent granted and the whole process that leads into that. So I'm excited to share some answers here to some questions I've gotten over this week from our avo.com community. And I welcome any and all live questions, of course, as we get into this program. I do want to make sure to put a legal notice out that while this is while I am an attorney, I'm not going to be able to give you legal advice in this session, being the public nature and all. So please do not share confidential subject matter. No, of course, this is not a legal consultation. There's no attorney-client privilege over the discussion. The ukulele is going to stay up there today. Sorry for those of you who are ukulele fans. I did have that last week. So aside from the legal notice, I'm just going to jump right in to these questions. I know last week we looked at some new school-related inventions. I know a lot of people have children going back to school. Ours went back just yesterday. Our little first grader and kindergartner, so cute. So anyway, if they missed that session, you can go back to our Facebook page or YouTube or our LinkedIn to watch those innovations. Today, we're going to look at 3 patent questions that have come in from Avo, and then we'll look at 4 trademark questions if we have time. But if you have any burning questions and you're watching live, I will prioritize them. So please put those in right in the comments. So this first question is out of Seattle, and I'll copy and paste it in here so you guys can see it. Okay, and this is a classic. Okay, so the question is, what can change between a provisional patent application and a full patent? If someone has filed a provisional patent application, what are they allowed to change before filing the full patent? Are there things that can be totally changed or things that shouldn't be touched at all? How does this process work? Thank you. Well, you're welcome. Let me just dig into this. So what I want to show first is this flow chart, and I did take a peek at this question before, so I was able to prepare this this flow chart that I like to share a lot of with new clients. All right, so this is the application process, and where they're at, this question is they just filed their provisional patent application. This is step B. So hopefully they did step A, of course, which is doing a patent search to make sure that they know what they're getting into before they file. That being said, they did already file. And now they're wondering, they've got this time period here between ending the provisional, filing the provisional, and when they call it the full, which is also called the final or the non-provisional formal application must be submitted within a year, okay? So the full year, a nice chunk of time to test your invention, discuss with third parties, take it around perhaps to investors to see if what you've got is really real, see if the market is demanding what you've built, and maybe to confirm for yourself that it works the way you thought it would. And you're right, the person asking the question is sometimes things change. You make a few, you do some customer testing and feedback, and you find that there are quite a few modifications or improvements and changes that should be made to your product. And you want to try to get those into the claims, right, into the subject matter of your invention as filed. So how much can it change is the key question. So let's jump back here at our question. So what I will say is that the key here is you cannot add new matter, okay, new subject matter. I know it's kind of a broad term, but what that means is you can't broaden. Okay, you've filed the provisional. That really is the bounds, right? The limits on what exactly is your invention. But what you can do is you can add details and color in a way, right? So if you found out that, let's say your invention is a new type of a Swiss Army knife, okay? And you talked about all the different features of the knife. You've got a blade, you've got a screwdriver, you've got a corkscrew opener, and maybe you've got this sort of a saw blade, right? Now, let's say over the course of that year, or maybe even a few months, you find that, well, for the knife, you actually needed to have a half serrated and then a half full blade on one of the blades. Or you wanted to include in the saw blade, more teeth You know, you needed to have actually a higher frequency of teeth, and they had to be sharper than you originally had identified in the provisional. Those sort of details would be fair, totally fine to add into the non-provisional. But let's say you wanted to now add a flashlight, or have the actual knife be, you know, double as a parachute, or somehow pop open and be a flare. And nothing was discussed in the provisional about a flare gun, or about, you know, having a the ability to have scissors or any other types of gadgets. So if they're functionally different, that's new subject matter, and that would be not allowed, right? You wouldn't be able to add that to the non-provisional and still be able to claim the priority of the provisional. So I know there's a lot of details there, but it was such a good question. I wanted to make sure we spend time on it. Hey, although we got 3 live viewers out there, just in case you missed the note, if you have any live questions, please put them in the comments below. Don't be shy here. No questions too easy or too simple. I love getting questions from first-time inventors, entrepreneurs, people curious about the patent process. What I will do is I'll put a link in here about 5 minutes from now about how you can schedule a free 15-minute information session with one of our advisors to see if now is the right time for your invention to move forward, and if you want to start protecting it. All right, so let's jump to the next question here. And this is from our avo.com community. The second one is here of LA, Los Angeles, California. I'll put this in the comments here for you guys to see. I will be prioritizing those live questions, so please keep those coming in. Hi there, I wonder where I can search the patent by attorney name. I want to see some previous work of the attorney that I want to work with. I tried the Google patent search, but it's only based on inventors, not the attorney name. That would be a great help if you could name a website I can search by attorney name and find their previous patents that they filed. Thanks a lot. Cool, this is nice. This is gonna put me to the test a little bit. So I do believe there is a search engine, and I'm gonna fumble through this, but hopefully you'll appreciate this a little bit. I'll share my screen and we'll look at it together. I will try not to take too long. So if I was gonna go try to find out information about application, patent, so I have a quick, I'll put this URL in the link here so you guys have it. Okay, so that is the search tool I use if I want to get some really detailed, information. So you see there's lots of different fields. Let's take a look and see what it's called. Attorney or agent, right there, LREP. So they've got a field code. I'm pretty sure you've got to type in LREP / let's just put in my name, LREP Houvener. Okay, so you can see that I am named as an attorney of record, my last name, Houvener, on 41 patents. Some design patents you can see, and some utility patents. Now, of course, our firm has filed more than 41. We've got a lot of attorneys. But yeah, that's a good way to do it, just by last name and LREP. You can do that. Another cool tool you can find within the Google patent search is the advanced patent search. And you can find out if you have the name of the inventor or the owner or the priority date, you can search that too. So I'll put at Google the advanced patent search. There's some pretty cool filters you can put in there. Okay. Good for you for doing some research on your attorney before you jump in. I think that's a good call. All right, let's go back to Avo and go to Corona, California. This was just asked one day ago, and it's kind of a lengthy question. Let's do this, okay. Okay. Again, a lot of these questions are gonna put me to the test. Are multiple claims in a patent application considered independent or are they variations of the primary claim? Are multiple claims in a patent application, provisional or non-provisional, considered individual independent claims? Or are they considered variations of the primary claim? And if so, would they be rejected if the primary claim is rejected? For example, there are two hypothetical patent applications, both having the same primary claim, but one includes a secondary. Okay, there's a second part of this question. And they give some cool hypotheticals here. So let's go through this. Wait for this to load in here. Okay, so here's the hypothetical. So person A files a patent for the light bulb. The primary and only claim is for a glass bulb, cap, wires, and lighting element. Person B files a patent for the light bulb. The primary claim is for a glass bulb, cap, wires, and lighting element. The secondary claim is for a powder coating on the inside of the bulb to soften the light. Okay, person A files first and is awarded the patent, and B's primary claim is rejected. Would A, person B be issued a patent for the secondary claim? Automatically. Or would they need to have filed a separate patent application for the powder coating? Okay, good question. So I think the best way to answer this is to say, okay, so person B, where they are improving, they're improving the bulb that person A invented. Improvement patents get issued all the time, okay? And they can be subtle. And in this example here, where they're adding a powder coating, right, to the outer part of the glass, the important question is going to be, is the addition of that powder coat, is that novel, non-obvious, and does it have utility? Okay, those are still the same questions. And if they're claiming either on an independent or a dependent, that's the question. Is that claim, what they're claiming, is it the first of its kind ever in the world, based on all publications, all known information? So meaning if in the invention of inventor A, person A, if they mentioned that the glass could be covered in powder coat at all in that application, in the spec, even though they never claimed it, that would still be enough evidence that the examiner would reject person B's invention because it's not new. It's already been discussed and published. But let's just say, for curiosity's sake, that this powder coating has never been heard of before. It's brand new, it's novel. And it's not an obvious version, right? Whatever they had currently been coating the glass with today, powder coat is not an obvious choice. It's not something that is a natural selection. If that's true, then yes, person B's invention, like I said, whether it's an independent or a dependent claim, it will get allowed, okay? So I hope that answers your question. You've got to be able to just show the examiner that it's novel, non-obvious, and has utility above and beyond the current publications. All right, so we've got a couple more trademark questions, and I didn't see any live questions come in yet, so we'll just keep on cruising through. All right, trademark applications. Lots of trademark questions. 4 came through. Let's answer this one from Kansas City. All right, can more than one person own a trademark? If 5 siblings develop a trademark, can all 5 be listed as owners on the application to the trademark registry? This is kind of an administrative question, not necessarily legal. I would say, I would guess not very cleanly, not very cleanly. I think usually you have to have one named applicant, okay? And one of the best ways to handle this, and even good advice in general, in terms of having multiple people, certainly siblings, just thinking of all the family debates and issues that can come up when you're emotionally vested in a company and a brand, you ought to have a business, okay? A simple partnership, an LLC or a corporation will do fine. And having a document, a corporate governing document, shareholders agreement, operating agreement, co-founder agreement to where all owners, right, of that company, assuming the 5 siblings would want to be co-owners, they have various responsibilities, obligations, investments. And then what's great is that you can actually have the trademark with the registration assigned to the company so that it's one entity that is the applicant and owner of the mark, and yet you've got 5 owners. That way they can potentially squabble, get into negotiations and have disagreements about what to do, but it's one company, and they can move and make a great decision as one, in a way, as opposed to having 5 different owners of a mark. So that's kind of my long-winded way to say I'm not 100% sure, but what I would recommend doing is forming a company and having it be the applicant be the business, especially if you've got 5 potential owners of a brand. All right, let's go to our second trademark question. This is out of Buffalo, New York, and it's about handmade goods. Okay. So can I make handmade goods or crafts depicting my home, state, and local landmarks legally without infringing state property laws? I make crafted decor and goods like key holders and wood plaques with original artwork on them. I'd like to know if I can make the shape of my home state, the actual geographical state or other states, with locations like major cities or local towns, landmarks, or skylines, safely for sale at craft fairs without risking any legal issues via state government or risk text. Excuse me. Yeah, sorry about that. Legal issues via state government or risk being taxed for the use of it without acquiring a license from the government. So this is actually more of a copyright question, and it's a little bit out of my wheelhouse. But what I will say is when you're, sort of some of the threshold questions to consider, if you are making art and you're doing it on your own, okay, using your own intellect, creativity, and you're making a shape from your own memory and your own thoughts, there's basically no way that you're going to be infringing. Okay, but if you're using images, using others' creative works as the basis of what you're creating, that's when things can get tricky. And I mean, artists build on each other all the time. So there's ways to go about this. So if you're looking at, if you just Google, a state map, right, the state of Washington, let's say, there's a geographic shape. And I think for the most part, the actual shape of the state, it's not artistic. I can't think of any reason or rationale for an individual or a company or a government to claim the ownership of the shape of the state. So if that's really all you're going for, I think it's extraordinarily low risk, if not zero risk, of reproducing the actual shape of the geographic state. Now, where things can get tricky is where there are reproductions, where individuals or companies have put forth effort to create maps. Maps are very valuable, and maps can be simple, right, where they've just got simple cities highlighted, where they got shapes or icons or details on roads and rivers. But that's actually someone putting effort in to create a map. I was showing points of destination, relationships, destinations, mileage posts. So all of that now gets to the point to where there's an individual or company that owns that right to that creation. Right? They put forth effort to create that map. So if you're using someone else's map, someone else's icons, colors, pictures, designs, and you're using that for your own business, your own commercial benefit, that's where things can get toward infringement, right? We're using someone else's work for commercial gain. There certainly are rules about fair use. I didn't ask about this, but I want to at least mention that if, of course, you want to try to use that for non-commercial benefits, let's say in the classroom if you're a teacher, or using it perhaps for a nonprofit use, there are ways to avoid infringement, but it is a sort of special case. So if you want to ask more questions, feel free to get a hold of me if you have any more specific about what exactly you've created. Copyright generally is going to require an analysis into what exactly you've done for me to provide viable, detailed information. So that's my contact information. And before I forget, I want to put down a way for any of you to book a free screening session to see if you want to have a discussion with one of our attorneys to try to protect some of your IP or intellectual, or your inventions, trademarks, or creative works. So there's a link right there to schedule, and it's a Calendly link, so you can plug that in. Copy that link and get booked today. And so it's a no fee meeting to get done today. I've got time for one more question. And again, I don't see any live questions, but if you have any, I will still do that one as well. All right, let's go to one more question about trademarks. This was out of New York, asked just last night. So pretty fresh question here. And I'll put that in the comments as well. Thanks for that like, appreciate it. Yeah, and if you're watching this after the fact and you want to join us live, I put the show on every Wednesday at 9 a.m. On the West Coast and noon on the East Coast. Okay, let's take a look at this one. So a trademark name was taken with similar name in the same area of business. I started my LLC, which is a business company, limited liability company, in 2015, but postponed the trademark until I got the company fully up after researching the trademark website for my name. I recently saw two very similar companies use my name with a slight different spelling. Would I still be able to register mine? And can I have the option for any legal action to these other companies, even though they trademark, but I established before they did? Please help. I'm a small woman-owned business. All right. Very good, very good. Thank you. Okay, cool. So let's see if I can follow that a little bit more. So it looks like there is some concern about using the name. So trademark law, okay, trademark law. Trademark is all about using a name, a word, or a logo or design to signify to customers that you want that to represent your goods or services. And so if you're using that mark, if you've used it in any way in commerce, meaning you've actually sold goods or you've sold services using that mark, that is sort of your first use date. Okay, that is the priority date when you say you first used it. And you could argue that from that date forward, assuming you've had continuous use of that mark, no one else can use that mark if they came after you for the same class of goods or services, right? So you're selling, ukuleles and musical instruments, well, and using the name, wooden rock, okay, wooden rock for wooden instruments. No one else is going to be able to use that name, wooden rock instruments, for instruments. But of course, they could use the term for wooden rock if they have a rock climbing guide service. Okay, it'd be a different class or a different use. So it sounds like you're saying you've started your company and you rolled it out maybe a couple of years later. Let's just stick with the wooden rock name. So you started selling, instruments in 2017 or 2018 or so, and then recently, 2020, you've seen, rocky wood, instruments pop up, or you've seen, similar misspellings or sound-alikes where they seem to be copycatting what you've done. Absolutely. So one, I would recommend getting a trademark registration for wooden rock. And you can get that done, as soon as possible. Obviously, you can use our firm to help you with that. Once you get the registration, you've got a lot of power. Now you have the ability to then cease and desist, send those letters out to companies that are using your name or a similar name without your permission. You could also then potentially seek to give them a license to be able to use that name, and you just get a simple lump sum or a royalty for every time that they use it. There's lots of different options, but as long as you are really the first one to use the name, you're scot-free. And there are a lot of mechanisms to enforce your rights on the internet. So for URL domain names, if people are just squatting on the name, or if they're not, or if they're infringing on your trademark, trademark rights will, in a way, trump and overrule any type of ownership of a website, because that is commercial use. And if they're selling to the US, they're not able to do that. And so you may be able to reclaim ownership through the domain registrar. So a lot of interesting and cool rules that are going to be helpful for you if you go down the path of seeking trademark registration. All right, guys, well, that's the end of our program. Thank you for tuning in. I'm JD Houvener, patent attorney, owner here at Bold Patents Law Firm. I'll be here with you next week, Wednesday. So if you miss us live, please join us and give us a like and share this with your community on social. We'll get this to be a more lively, interactive group. Thanks a lot, everybody. Have a good rest of your day. Go big, go bold.